Hello and happy Tuesday to everybody. Thank you for joining us today for our next webinar in the Secrets of a Successful Retirement series. Today we have a special guest, Andrew Friedman, attorney at law. He is going to be leading this presentation today. My name is Tara Kendrick, and Bill today is actually on vacation, so he's taking a little break from us, but we'll miss him. All right. So at Senior Resource Center, we help in 4 different ways. We do comprehensive retirement planning. We look out in 30-year plans to make sure that families aren't going to outlive their money, and making sure that they have all of their plans in place to do so. Second is we help with tax planning and just finding ways in different areas of retirement to learn to pay less tax. And we just recently did a presentation on that. The third area is long-term care planning. We help thousands of families qualify for federal and state programs, including Medicaid to pay for long-term care, VA benefits for veterans and their spouses, and then also other ways to do long-term care planning, including annuity benefits that have a doubler effect and long-term care insurance. And then last, we do estate planning. So just looking at someone's overall estate, making sure that they have beneficiary designations on assets, and then, of course, leading them to an attorney to help with any legal documents that they may need and make sure that they have their legal house in order for when they're living and when they're gone. So with that being said, we do have to have a small disclaimer that, everyone's situation is very unique, and, your situation determines what kind of legal documents you may need. Bill and I are not attorneys, and we always refer any of our legal questions to a licensed attorney. So without further ado, I'm going to pass this off to a licensed attorney, Andrew Friedman. Hi, Andy.
Hi, Tara. Well, let's see. Today we're going to be talking about trusts. My practice as an attorney is in estate planning with a focus in elder law and asset protection, but a very strong focus on trusts. So this is my bailiwick, if that's the right term. I'm going to start off with kind of overview information and then gradually drill down. But do understand trusts are enormously complicated, or they can be, and it's a rather complex field. So I am, for the purposes of the seminar, kind of dumbing down a lot of the concepts so we have good building blocks to work from. So diving right in. First off, what is a trust? Well, technically, it's a legally recognized relationship between 3 people. And this kind of relationship is almost invariably put down in writing. The 3 people involved in the relationship, the first one is the one who sets up the trust and puts property into it. There are about 10 different terms, but the most commonly used are the grantor or the settlor or the trustor or the trust maker. Again, this is all different terms for the same person. It's the one who sets up the trust, sets up the rules, and puts property into it. The second person is the trustee. That's the one administering it. And the third is the beneficiary. Now let's go over those basic terms one more time. I want to make sure this is as clear as possible. When you hear grantor or settlor or trustor, you're talking about the one who makes the trust. I think of it most easily as the trust maker, but any of those other terms mean exactly the same thing. And when you set up the trust, when you define the terms, you actually have to put something into it, or legally it doesn't exist. In some ways, it's kind of best to think of a trust as a bucket. You design the bucket, but you have to put something into it, and that's called funding it. Funding it is the second major purpose for the trust maker. The second person in that 3-person relationship is the trustee. Now, this is sometimes confusing, but to be clear, the trustee is the legal title holder to the property in the trust. So this is more powerful than an agent under a power of attorney who's acting for the legal owner. The trustee actually is the legal owner of the property inside the trust. They administer and control the assets, the property inside the trust, according to the trust terms. The third person in this relationship is the beneficiary. This is the one who benefits from using the trust. The beneficiary can be the trustee. The trust maker can be the trustee. In fact, the trust maker can also be the beneficiary. So just to be clear, the roles are established, and then part of designing the trust is determining who fills those roles. So I mentioned earlier, trusts are enormously complicated. They can be, but I think the greater complication is how many different kinds of trust there are. The last time I had one of my colleagues go through it, he came back and reported there were 65 different kinds of trust. So just using the word trust by itself is usually, at best, misleading and confusing, but can actually lead you in the wrong direction. Just understand it's a term that has a lot of different subcategories. What I'm going to do in our presentation today is break it into 3 categories that I think make sense to me. One is going to be based on when the trust is established. The second category will be whether you can change the terms of the trust. And the third will be, how is that trust taxed, income taxed? The first of the ones that I'm going to talk about is whether you can change the trust. The terms that are used broadly are revocable versus irrevocable. Basically, it's can you change it and revoke it, or is it set in stone? The most commonly known of these terms is the revocable living trust, sometimes just called a living trust. You can have standalone revocable trusts, for example, retirement trusts or educational trusts using a 529 plan. You can set up irrevocable or unchangeable trusts, and the abbreviation is almost always IRT, irrevocable trust. Examples of that are life insurance trust. The acronym there is Irrevocable Life Insurance Trust, or ILIT. Standalone dry trusts are there's something that's waiting to spring into being. Again, if a trust doesn't have anything in it, it doesn't exist. And a dry trust, or rather the dry trust doctrine, says that if you don't have something in the trust, it has no legal existence. Intentionally defective trusts, IDGT, intentionally defective grantor trusts, are usually used for tax purposes. And then inter vivos Q-tips. A Q-tip is a means of dealing with the estate tax after both the grantor and his or her spouse have died, taking advantage of certain distinctions set out in the Internal Revenue Code. But anyway, these are just examples of irrevocable trusts. The most commonly known trust, and the one that most people are referring to when they say use a trust, is defined as a revocable living trust. This is an alternative to using a will-based plan. It is an estate planning vehicle. It's usually established, as are most trusts, by a written document. Property that is held in this revocable living trust is not subject to probate. It's effective as soon as you sign it, and its contents are basically instructions for how to manage the property in the trust, both during the lifetime of the grantor and during any term of disability of the grantor, and then again after the grantor's death. It directs how creditor payments are to be made, and it distributes the net amount in the trust after the grantor has died to the people who should receive it. The second category I talked about was the tax distinction, and that falls into grantor trusts versus non-grantor trusts. A grantor trust is a trust that has a tax ID that's set under the grantor's Social Security number. In other words, it's invisible to the IRS. If a grantor sets up a living trust, the property in it is still tied to his or her Social Security number. So there is no separate tax ID number for the grantor trust. What this does allow is to shift the legal title of the property from the grantor to the trustee. Now remember, the trustee is an office, and it's filled by the people that the grantor has designated. So one of those people can, and quite often is, the grantor himself. The grantor sets up the trust, shifts legal title to the trustee, and then says, I'm serving as the trustee. But it also allows the grantor to set up successors in case the grantor becomes incapacitated, or then again after his death. The title stays in the trustee, but the trustee is an office that's filled by the people set out in the trust. In a basic grantor trust, the grantor retains the income tax obligation. Remember, it's tied to his or her Social Security number. So if there's any income generated by the property in the trust, that's income directly to the grantor. Following up on that, as the trust income is taxed to the trust maker, all its expenses flow through to the trust maker, the grantor, at the same time. And this is one of the tools that's used in more complex planning, if someone sets up a grantor trust, and again, this grantor trust has the same Social Security number as the grantor himself, and then he sells property from himself to himself as trustee, it doesn't trigger an income tax. I just want that concept out there. Diving into it and why you would use it gets fairly complicated, but I just want you to know that is out there. So you have essentially a trust. In this case, it would be an irrevocable, unchangeable trust, but it is a grantor trust with the same tax ID, the same Social Security number as the grantor. So the grantor can own something in his own name and sell it to himself as trustee, and it changes the legal title. Now, the income tax that the grantor pays, because it's due on income that's generated by property held in the trust, that income tax payment is not a gift to the beneficiary of the trust, because as you recall, it's tied to the grantor's Social Security number. So one immediate advantage is if a grantor sets up a trust and the beneficiary is a child, and then the grantor puts property into the trust, and that property generates income, the grantor can pay the income tax on that would otherwise be due from the beneficiary, because it's a grantor trust and it's the grantor's responsibility. That is not considered a gift. It's simply payment of the income tax. Once again, I'm setting out that concept there, not delving too far into why you would do this, just to let you know it is a possibility and it's used quite often in income tax planning. There's another kind of grantor trust. It's called, the acronym is an IDGET, an intentionally defective grantor trust. In this case, just like the earlier grantor trust, the property is moved out of the grantor's estate into the trust. But it's made intentionally defective so that the income tax obligation remains the grantor's. It's not considered, again, the property is not considered part of the grantor's taxable estate at death, but the grantor or trust maker is still liable for its income tax. What's the opposite of that? A non-grantor trust. You actually set up an irrevocable trust, that is an unchangeable trust, transfer property into it, and the trust has to establish its own taxpayer identification. It's a separate taxpayer. It gets its own EIN. It has to file its own tax return, and trust tax accounting can become complicated. Any income that's received and expenses that are paid are taxed to the trust itself. Now, the income that's generated is subject to tax at the trust, or the trust can be designed to distribute out that income each year to the beneficiaries, and then it gets taxed to the beneficiaries. If a trust accumulates the income, which is to say it doesn't pay it out to the beneficiaries, it just holds on to it, then the trust pays the tax. If it distributes the income out to the beneficiaries pay the tax. What are some of the reasons that you would keep property or that you would transfer the property out? Because you set up the trust for purposes initially. Why would you immediately send that income out? One of the biggest reasons is the marginal income tax rate. When a trust retains income and it has its own taxpayer identification number, it gets to the top marginal income tax bracket at $13,050 of net income. So there's a chart here, and it shows just a comparison between a married person or married persons, a single person, and a trust at various levels of income tax. At the 24% level, a married couple has to have earned $172,751. A single person has to have reached the level of $86,376. A trust hits that marginal rate when it earns $26.50 in tax, in income. At 35% bracket, a married couple has to have attained $418,851. A single person, about half of that, $209,426. A trust hits 35% tax at $95.50. And the current highest level is 37%. Again, a married couple has to have earned $628,301 before it gets to this level of taxation. Single person, $523,681. A trust at $13,050 of income is at the highest marginal income tax rate. So that's a very strong suggestion there that you have a provision in the trust that distributes the income that's generated each year out to beneficiaries, unless there's some reason not to do so. All right, it's going rather fast, and I apologize, but at the beginning I did mention this is a very complex area of law, and I'm just trying to put the building blocks into place. There are some terms here that are used quite often in trust-based planning. One is continuing trusts. That means, in essence, a trust maker sets up the trust and it continues beyond the grantor's life. So it goes on, the trust morphs into a trust for the benefit of children, for example. Suppose you want that trust to continue not only during children's life, but through grandchildren's life. Then you have set up what's called a multi-generational trust. It goes from the grantor to the grantor's kids to the grantor's grandchildren. And then the last logical extension, this is what's called a dynasty trust. This was established very early on in the early 1900s by families with enormous amounts of wealth, like the Rockefellers and the Vanderbilts. They set up dynasty trusts that continue from generation to generation like a dynasty. And all the property is held in that trust as long as there is a family member alive. So with all these different things, the different categories of when you set up a trust, is it set up during your lifetime like an inter vivos or living trust? Is it set up through your will in what's called a testamentary trust? And the term testamentary there simply refers to the fact that it's created in your last will and testament. Do you want it changeable or revocable? Are you allowed to go back and tinker with it if it doesn't meet your needs at some point in the future? Or is it fixed and irrevocable? And the third is, how is the income that's generated by trust property taxed? Is it taxed to the trust maker or grantor? Is it taxed in the trust itself? Is it distributed out to the beneficiaries and taxed to them? Those are the three categories. What are some objectives you can address? By setting up a trust, you can provide asset protection for your spouse, your descendants, and other named beneficiaries. You could reduce or eliminate your current and future income taxes. You can provide for future estate and generation skipping tax inoculation. I'm not certain why I use that term, but basically it's preventing the application of generation skipping tax. And what are some examples of asset protection? What are some real life needs that might cause you to consider using a trust for asset protection? Well, let's see. Suppose you're a married couple. One of you dies, and the survivor of the two of you remarries. And then that survivor and new spouse get a divorce. Well, in Texas, any property that's community property is subject to division by the divorce court in any manner that the divorce judge thinks is just and fair. That's it. Those are the three words that define their limits. So that could be 50-50, which you would hope for. It could be 75-25, 99-1, 100-0. It really depends on how good the divorce lawyers are on the side of each person in the divorce. A second real life need is, suppose you leave property to your child or children, and they get married, or perhaps they're married at the time and their marriage fails. Once again, you can't prevent a divorce from happening to a third party, but what you can do is remove part of the reason that might exist for the divorce in the form of readily available assets. If you leave property to a child and that child is married and they put it in a bank account with their name or both their names on it, it doesn't really matter with the name on it, the divorce court can divide it. If you leave it to them in trust, the children can use it for their benefit, which can include their spouses while they're married, but the ex-spouse in a divorce can't get at it. Suppose you leave property to your surviving spouse or to your children, and something happens to them after your death. Child gets in a car accident. Spouse or child commits malpractice. They're doctors or do something that leads to that kind of liability. Spouse or child running a business and the business fails. Or there's a co-signatory, someone else who can sign on an account for the surviving spouse or for the children. These can all lead to liability and potentially lawsuits against either surviving spouse or children. And if you leave property through your will to someone outright, it's exposed to all those forms of liability. And then the last one is a little bit more vague, but future wealth transfer taxation. Everyone has probably heard of the federal estate tax, and that's a tax on property that's transferred at the death of someone to another person. If the amount being transferred goes over a certain threshold, and currently it's a very high amount, but Congress is considering reducing that rather drastically. But if it goes over that, it's taxed. And it's not just the income that's taxed, it's the full principal. The total value of the estate is taxed over that, whatever the threshold is. And the tax amount currently is 40%. I understand most of the tax bills that Congress is considering to change this would raise it from 45 up to as high as 65%. And remember, this is a tax on principal, not the income generated by the principal. It's a huge tax. So dealing with that in advance makes a certain amount of sense. All right, I just like this picture. Think of your trust as a toothpaste tube, and the assets in it are the toothpaste. As long as the toothpaste is inside the tube, it's not exposed. But as soon as you take off the top and you squeeze it out, it's exposed. So that's just how I look at asset protection, as kind of as toothpaste. And again, this term I stole from someone else, and in retrospect, I'm not certain it's entirely accurate, but the magical mystery power of trusts is based on a question. If you could protect it all, why wouldn't you? Okay, I have finished the initial presentation. I wanted to leave enough time for some questions, and I think Tara has some to report.
Yeah. So if you haven't been with us before, at the top of your screen, there's a talk button, or sorry, not a talk bubble looking thing that you can click on, and you can type in questions if you have them. So let's see if we have any questions right now. So I think you touched on this a little bit, but Andy, can trusts help with taxes?
Yes, they can. And this can become rather complicated, but let me give you one simple example, as well as simple as trusts allow. If you're a married couple and one spouse dies first and leaves, let's just say the husband dies first and leaves everything to the wife, there is no estate tax on that transfer. And the reason is the IRS deals with married couples as a single taxable entity. So property that passes back and forth during life or a death by gifts doesn't generate a tax. The question comes up, unfortunately, when the survivor dies. And here's the thing to remember. There's no tax between spouses during life, but each individual spouse has an exemption against the estate tax. And again, I mentioned it's very high now. It's 11.7 million, but as I mentioned, Congress is considering reducing it.
And was that 11.7 million per person in
That's
a couple?
11.7 per person.
Okay.
So collectively, you'd say that's 11.7 times 2, that's 23.4 million. That's a fair amount of change. If the first spouse leaves everything to the second spouse, and they make use of what's called the tax deferral between spouses, then only one of those two 11.7 million exemptions is available to the survivor. It's kind of like a coupon. It's sometimes called a coupon trust, what's called a bypass trust, is if husband leaves everything to wife and says, all right, you're my spouse, so you just get it and there's no tax. That's correct. But the surviving spouse has only her own exemption, her own 11.7, cannot exercise the first to die's exemption. So you've cut the estate tax protection in half. Now again, at 11.7 million, you may say it's dancing on the head of a pin. It's not really that big a deal. But if they reduce that to say $1 million, which is one of the things being considered, then if you have a house and a life insurance policy and retirement plans and any investments, you're way over that. So 2 of those exemptions, 2 million, would be able to shield a lot. 1 million would not, and you would have a lot of that exposed. The mechanism, the trust that helps with this is called a bypass trust. It simply says, in the simplest form, at the death of the first spouse, that spouse's property doesn't go directly to the survivor, but instead goes to a bypass trust that benefits the survivor. But it's not considered the survivor's property, so that when the survivor dies, only her half is taxable, and the property that went from the first to die, from the husband to the bypass, is treated as having been taxed and exempted already. So you make use of both of the exemptions through a bypass trust. I hope that was somewhat clear.
Yeah, wow, that's a lot. Okay, and just from our side, we get this question a lot, is can trusts help with Medicaid? Now, my short answer is sometimes that families will come in and they'll have put say checking accounts in a trust, which is not a big deal because the trust can own the checking accounts. But when they put a home inside a living trust, then Medicaid says it's now a countable asset, where normally your house is exempt if it's outside the trust.
Okay, and I do see a follow-up question. Ladybird are actually a deed, not a trust, but the question you have and the one that started that is, if you put property into a trust for estate planning purposes or tax purposes, and then you have to qualify for Medicaid, the fact that the home is held in the trust means it's countable against the person applying for Medicaid. So you want to have a provision in the trust that said, in that circumstance, the property, the house, can be distributed back to the individual name of the trust maker that's trying to qualify for Medicaid. There is a more specific trust that can be used not in that circumstance, but it can help with Medicaid, and it's called a special needs trust. If a parent, for example, is leaving property to a child, and that child has qualified or will be qualifying for Medicaid, the Medicaid qualification from the financial front is very drastic. You can't own more than $2,000 worth of assets. So this might be a situation where a parent, motivated by love, causes a problem for the child by leaving them money that puts them over the $2,000 amount. So use of a trust is very helpful here. The parent can leave the property to the child in what's called a special needs trust. It's designed a specific way, and Medicaid has agreed it's not part of the Medicaid applicant's estate, so it doesn't count against them.
Now, just to clarify the word property, we're talking about a home. We're not talking about things.
No, it could be anything.
For the Ladybird, for the special needs?
For the special needs trust can be anything. So
Okay.
if you leave investment accounts, a home, real estate, unimproved property, any kind of asset you can come up with to someone who is qualifying for Medicaid, and that property has a value. If you leave it to them outright, it can kick them off Medicaid.
Oh, I understand.
But if you leave it to them in a special needs trust, it's as if they don't own it.
Okay.
So it works for their benefit.
Okay. So I mean, in the real world situation, that would be someone's on my father's on Medicaid. Okay. And then for whatever reason, I decide to leave my assets to my father instead of my husband.
Mm-hmm.
But I die before he dies.
Okay.
Then if I die without putting it in a special needs trust, now all that money and assets are dumped in his lap. He's off Medicaid.
That's
But
correct.
if I put it in a special needs trust to my dad, then it's not eligible. I mean, it doesn't count against him.
That is correct.
Okay. But then we kind of use these terms with what's another word for ladybird? Like we use the words ladybird deed.
Mm-hmm.
It's a special warranty deed? Or so what's the other legal term for a ladybird deed?
Okay. A ladybird deed is in fact a variation of a special warranty deed. The specific or legal term for it is an enhanced life estate deed, which means essentially the person who owns the property, let's say a mother wants to leave it for a child, but doesn't want to, and let's take it further because the Medicaid context is why this is used. The mother is not allowed to give away her house to anyone because that's seen as a disqualifying transfer. If she makes a deed to her child in a specific form, which is broadly referred to as a ladybird deed, but as I mentioned, it's an enhanced life estate deed, the mother actually owns the home throughout her whole life, but at the instant of her death, her interest in it is extinguished. So the ownership from the point of her death on is transferred to the child. The way the ladybird deed is constructed, the mother reserves the right to change her mind about that through her entire life. Since she can change her mind and give it to someone else or sell it out from underneath her child, Medicaid has agreed she hasn't actually gifted anything, because it's like making a gift to someone and then holding on to what you're transferring. If you don't let go of it, it's not a gift. So for that reason, it's not a disqualifying gift.
Okay. So basically they can shift it to that type of trust. Deed through a deed. And then they can own it. They still own it. They could sell it, lease it out, do whatever they want. But the way that the state looks at it is at the moment of our death, then that's when the transfer occurs.
Exactly.
So, okay, that makes sense. So I think we probably answered the other question that someone asked. Can a trust shield income for the purposes of qualifying for Medicaid or VA benefits?
It's usually used in a special needs trust to protect the principal, but anything that goes into the trust could possibly generate income. So if that income is in the special needs trust, the income along with the principal is not considered owned by the applicant for Medicaid. So it is shielded, and yes, I guess it protects, for Medicaid purposes, the principal and the income from disqualifying the applicant for Medicaid.
Okay. All right. Well, if no one else has any other questions, I know this was a big, heavy, kind of complicated presentation, but well done, Andy. I think you did it the best you can as being an attorney.
Thanks. I appreciate it.
So if you guys have any further questions or specifically want to speak with Andy about your own personal situation, up on the screen, I do have his phone number to the office as well as his email. You're always welcome to call and ask questions or send him an email. After today's presentation, I will be sure to send everyone out an email with a recording of this presentation if you want to watch it again or pass it along to someone you know. And then next week, we'll be doing a presentation on philanthropic giving and how you can use your estate to do that and find ways to actually save on taxes as well. So it's definitely one to listen to, and we'll have another special guest, Jeff Fine, who will be helping us with that presentation, one of our other partners. So if there isn't anything else, we thank you for joining us today, and we look forward to seeing you next week. So have a great day. Bye-bye.